Yo, 12 messing with you? This is what we could do for you.
Watch out now.
Defendant's motion to dismiss. Defendant Herbert Vanderbilt Alexander, pro se, and pursuant to Rule 3.190C4, Florida Rules of Criminal Procedure, hereby moves this honorable court to enter into an order dismissing the above captioned cause. As grounds for this motion, defendant states that the material undisputed facts alleged by the state of Florida should correspond with the discovery provided by the state of Florida. This includes a Freedom of Information Act request that was submitted to the Miami Shores Police Department on November 24, 2025, pursuant to the Florida Public Records Act, Chapter 119, attached as Exhibit A, and defendant contends that this case represents an abuse of legal process stemming from ongoing organized harassment, with the arresting officer's conduct being directly tied to a prior interaction where defendant sought lawful redress. In support thereof, defendant states as follows. Background. Number 1. On November 22nd, 2024, defendant was crossing the street near 103rd Street and North Miami Avenue in Miami Shores when law enforcement officers engage him without articulating a lawful reason for the stop or detention. Number 2, one of the arresting officers, identified as N. Allen, court ID 011-00235, that's 011-00235, had previously interacted with defendant the night before, on November 21st, 2024, during a separate incident near Miami Shores Elementary School. Number 3, during that prior interaction, defendant requested Officer Allen to document and provide a police report concerning organized harassment defendant was experiencing, in line with allegations described in case number 423 CV 01013, USDC, Southern District of Texas, Houston Division. Number 4, Officer Allen refused to assist, instead insulting defendant and leaving the scene without fulfilling his professional obligation. Number 5, defendant subsequently filed a formal complaint against Officer Allen with the appropriate department on the same night. Number 6, defendant contends that this complaint directly influenced Officer Allen's conduct during the current incident, including the use of intimidation tactics to provoke defendant into a reactive state. Arguments. A. The arrest stems from retaliatory and harassing conduct. Retaliatory police action in response to a civil complaint constitutes an abuse of power and violates the constitutional prohibition against retaliation for protected activities under the First Amendment and the Due Process Clause. The U.S. Supreme Court in Hartman v. Moore, 547 U.S. 250, 2006, held that retaliatory actions by law enforcement, even nominally legal, are actionable when motivated by retaliation against constitutionally protected conduct. Defendant's formal complaint against Officer Allen constitutes protected activity. The subsequent harassment, intimidation, and arrest presents a direct retaliation against the activity. The actions of Officer Allen and other officers reflect a coordinated effort to undermine defendant's credibility and to retaliate for defendant's attempts to lawfully document organized harassment. B. Organized harassment in the abuse of law enforcement resources. The broader context of organized harassment, as alleged in case number 423 CV 01013, USDC, Southern District of Texas, Houston Division, provides relevant context for this case. The defendant's allegations regarding organized harassment include coordinated efforts by law enforcement and other entities to disrupt and intimidate. Law enforcement's misuse of resources, including initiating baseless stops, is consistent with the patterns described in the aforementioned case. In Adams versus City of Annapolis, 2022, WL 364877, D.MD, the court highlighted the patterns of targeted harassment including repeated baseless police interactions, constitute a cognizable civil rights violation. C. Evidence of pretext and retaliation requires dismissal. Florida courts have held that dismissal is appropriate where prosecutorial action arises from improper motives as part of a retaliatory scheme. The facts surrounding this case, including the prior interaction and complaint against Officer Allen, demonstrates a retaliatory motive that taints the arrest and subsequent charges. Florida Statute 838.022 prohibits misuse of public office to retaliate against a private citizen. Officer Allen's conduct violates this statute and undermines the integrity of the charges. The elements of lawful execution of a legal duty require an officer to have either a founded suspicion to stop the person or probable cause to make a warrantless arrest. EAB versus State 851 SO2D 308 311 FLA 2nd DCA 2003 IYD versus State 711 SO2D 202 203 Florida 2D DCA 1998 SGK versus State 657 SO2D 1246 1247 FLA 1st DCA 1995. Number 2. The crime of resisting an officer without violence does not take place if the officer lacked an articulable, well-founded suspicion of criminal activity to justify the attempt to detain the defendant. Harris versus State, 647, Southern 2D 206, FLA, 1st DCA 1994, SGK versus State, 657, SO2D 1246, 1247, FLA, 1st DCA 1995. For this reason, the unlawfulness of an arrest or detention is a recognized defense to a charge of resisting without violence. State versus Anderson 639, Southern 2D 609, 610 to 611, FLA 1994. Number 3. Where a police officer conducts an unlawful arrest or detention, an individual has a recognizable right to resist those unlawful actions without violence. Hadley versus State 846, SO2D 1236, 1238, FLA 1st DCA 2003. A defendant is furthermore entitled to a jury instruction of this principle, and a failure to give the instruction constitutes reversible error if there is any evidence to support the instruction. Number 4. In the instant case, the undisputed material facts establish that the only conduct engaged in by defendant within the knowledge of police was defendant attempting to cross a public street. Number 5. The conduct of defendant observed or known by police officers at the time of the alleged incident was protected First Amendment activity and in no way provides the requisite probable cause or founded suspicion that defendant had committed, was committing, or was about to commit a crime. The officer's attempted detention of the defendant, Herbert Vanderbilt Alexander, was therefore unlawful, and defendant under no legal obligation to comply with the officer's directives. Number 6. Without sufficient legal justification to detain defendant, the crime of resisting an officer without violence could not have taken place. Harris 647, SO2D at 208, SGK 657, SO2D at 1247. As such, the disputed facts do not establish a prima facie case of guilt against defendant, and defendant is entitled to dismissal as a matter of law. Conclusion. The charges against defendant arise from an unlawful stop and deliberate provocation by law enforcement officers, in clear violation of Florida statute and constitutional protections. The officer's conduct undermined the principles of justice and fairness, rendering this case untenable. Wherefore, defendant respectfully requests this honorable court to, number 1, dismiss all charges against defendant in this matter, and number 2, grant such further relief as the court deems just and proper. Message us at facebook.com/hip-hop lawyers with an S. This ain't legal advice, by the way.